Hello, this is Heejun, and I'm a South Korean lawyer. Today I want to talk about commercial software privacy in Korea. So this main topic is to distinguish copyright infringement from contract breach. So the first point that I want to make clear for today is installation alone constitutes copyright infringement in Korea. So under Korean Copyright Act Article 16, saving software to your hard drive is already reproduction. So this means that installing programs without legitimate licenses or using cracked files to bypass technical protections measure is textbook copyright infringement. Seoul Central District Court confirmed this in 2017. Even acquiring pirated software knowing is illegal and using it for business violates Copyright Act Article 124. Of this basically means that I don't know, this kind of excuse rarely works as it depends when it comes to South Korean copyright law. Then the next question is to distinguish the contract breach from copyright infringement. So knowing the difference of those two is very important. The Supreme Court clarified this in 2017. So violating license terms like using educational licenses for commercial purposes is contract breach, not copyright infringement. But exceeding concurrent user limit, for example, that's infringement. So if you bought 5 user licenses, but 10 people use it simultaneously, then the Supreme Court ruled in 2018 that this copyright infringement because the excess copies have independent economic value. If that's the infringement of copyright, then what the damage can be. And the answer to this question is from Copyright Act Article 125. So this article requires paying what you have paid for legitimate licenses. So a design company using Adobe Creative Cloud for 3 years faces damage of 2 million won in subscription fee plus late payment interest. And another example, so for CAD or 3D programs with modular pricing, if you install the full cracked suite, then you pay for all modules, not just what you used, which people often misunderstood. And the problem for the CEO of the company, so involved in copyright infringement, he could face also personal liability. So even if employees installed pirated software, companies are liable under Civil Code Article 756. So CEOs personally face liability too. To make it simple, they have a duty to supervise employees against copyright infringement. So Suwon District Court ruled in 2022 that negligent CEOs can be held liable under tort law. However, if companies provide regular copyright training, purchase legitimate software, and employees install programs personally without business use, CEO liability may be avoided. And what happens if student licenses are not safe? So buying cheap educational licenses online is risky. To make it simple, Seoul Central District Court ruled in 2021 that selling student-free production kits to the general public constitute contributory infringement. Copyright Act Article 46 prohibits transferring license to third parties without copyright holder's consent. So the Supreme Court confirmed this in 2022 as well. This violation can lead to criminal prosecutions. So it's important to protect your company, to audit all software licenses, and conduct regular copyright training for employees with documentation, and to establish internal policies prohibiting crack programs and some illegal product keys. If you have further questions about the software copyright infringement case in Korea, then please leave your questions or comments in comment section.